HHS into brackets children.
Good morning.
Good morning, my lady. May it please the court. I hope the court knows that I represent the appellant children through their guardian. I appear alongside Miss Picos, who sits behind me. We were both at trial below. To my right, Mr. Toomey KC is new to the case, was not at trial below, leads Miss Watson behind him, who was at trial. Miss Ancliffe for the mother, Miss Ancliffe KC for the mother, leads Miss Croft, both were at trial, and Miss Zeitler for the father on the end. This is an appeal, my lady, from the fact-finding decision of Her Honour Judge Reardon. We have all filed skeleton arguments, of course, as per the rules, and I wanted to touch, if I may, in opening, on a couple of brief points. One is the nature of the injuries to A, and then the other is the point of the fact-finding hearing. Before I move on to the legal framework, can I say, by way of a preface, that this is an appeal in its preparation that has brought us back to fundamental issues, and I'm very, very conscious that to an experienced bench that I'm in front of today, I may be stating what feels like the obvious, but it's brought us back to those fundamental questions. And I want to apologise in advance if I am stating just the obvious. I don't mean to, but in our submission it's necessary. So the first point...
Before you go on, you can also take it that we have read, all of us read widely.
I'm very grateful. The first point is about these injuries. These are significant injuries.
I was going to ask you this, Mr. Tuan, and I don't want to cause distress for anybody in court. But I think that we are quite anxious to know what the current situation is about the child who was injured.
Thank you, my lord. Everything has been on hold. There has not been any opportunity or ability to put together a narrative for the children. If my lord is asking about medical condition now, I'm going to have to turn around at some point. I'm very happy to do that.
Well, at some point, I think for my part, I think we all would. Reading the medical reports, we're anxious to know how the child is.
Of course, my lord, and I apologise that I'm...
It may well be that you can't answer that at this relatively early stage, but for my part, I'd like to know.
Of course, my lord, and I apologise I can't answer that immediately. We will answer it to the best of our ability in due course. Oh, I'm very grateful. Miss Picos can answer it. Thriving, no long-term issues known.
Really?
That's
extremely
lucky.
Reassuring, because the lobe damage is quite an unusual injury to come across in these cases, in my experience.
Respectfully agree. Very rare.
Well, that's good news.
So, my lord, I can probably take much quicker the significance and seriousness of the injuries given my lord's helpful intervention. The other point I wanted to make about the injuries, not only that we're very well over the significant harm of section 31, we're into very significant injury, is that these are injuries on more than one occasion. There may be a debate about whether it's 2 or 3. I'm happy for the purposes of this appeal and was happy for the purposes of the trial to leave it at more than one occasion.
Well, that's how that you can't go further than that, can you? If on the basis of the timing, there were at least 2 injuries, and arguably, if 2 of the injuries occurred on the same occasion, they were different mechanisms. So,
thank you. Agree.
In a sense, dissecting that doesn't add to your case.
Respectfully agree.
Detract from it.
Thank you.
And there's quite a lot in the experts meeting minute when Professor Stavros and Mr. JMO and are debating the possibility of it all occurring on one occasion. They effectively say it's conceivable, but on balance,
yes,
not, and the judge so finds.
Yes. Thank you again, my lord. I respectfully agree with all of that. The other part of the framework here is, and this is really very important, is that there is no challenge to the finding of inflicted injury. And that informs in our submission that is coming, that should have informed the judge much more than it did. And it informs this court someone has inflicted. These are not accidental injuries, and they are on more than one occasion. The formula that we are content with, as just discussed with my Lord Justice Baker, which, although we talk routinely in cases of non-accidental injury of momentary loss of control in a parent, we are in at least two such losses of control. We are in the realms of a course of conduct here. None of that, as I understand it, on the mother's skeleton argument in response or on this judgment is in dispute. And so the issue in this case is, what should a court do with the conclusion that the injuries were inflicted when there is a list of one perpetrator? And that's the heart of this case.
Well, was there a list?
Well, Her Honour Judge Reardon ducked the issue of the list, and we say that's fundamental.
Well, and I'm not for one moment seeking to cast blame or was she presented with a? How was it presented to her? Was she presented with a? Was it pleaded, insofar as one has pleaded in this division? Was it pleaded that there is a list of one?
My Lord, the one thing I agree with the mother's respondent's skeleton argument on is that this is not a pool case and was not put on that basis. By the time of closing submissions, we, having explored the one text message that suggested the father may have visited once, no one said there was another person on the list. So by the time of closing, I hope this answers my Lord's question, it was obviously, factually, a list of one. Now, I'm slightly jumping ahead, but I'm happy to do so. The mother's skeleton argument in response to this appeal seeks to assert that she was saying there were other people on the list. She was not. The mother's skeleton argument in response to this appeal confuses, with respect, opportunity versus evidence of possible perpetration. By which I mean there were others fleetingly in touch with the children, but there was no evidence of an injury. There was no eyewitness evidence of injury being inflicted. There was no evidence of sequelae to a serious injury, child's presentation. And by the close of the evidence, this having been explored in evidence, no one said that the father was possibly or was on the list to be included or in a pool. And so by the time we all sat down after closing submissions, notwithstanding the mother's evidence of opportunity only, there was a list of one. One of the parts of the law that I wanted to take this court to, with the already professed nervousness about the obviousness of it, is the opportunity point. Can we go, I hope speedily, to the judgment of Re B, unknown perpetrator? The part I want to look at is in the authority bundle at page 74.
Have we got the threshold document and the responses there too?
Supplementary, my lord.
Ah, thank you. One, I missed that.
And the local authority's opening note.
Yeah.
So, my lord, can I hope...
Carry on. I didn't interrupt you.
You're taking us to read.
Not at all, my lord. And I hope to pick up some pace here. At paragraph 49, which is authorities bundle, page 75, the suggestion of the change in practice to the list. Well known to this court, I'm sure. The court should first consider whether there is a list of people with the opportunity to cause the injury. It should then consider whether it can identify the actual perpetrator. Only if it cannot identify the perpetrator to the civil standard of proof should it go on to ask, in respect of those on the list, is there a likelihood or real possibility? Also obvious to this court will be the difference in standard of proof. The perpetration finding is on the simple balance of probabilities, and the real possibility test comes in if one is dealing with a list or a pool of perpetrators. I am not saying this is a pool case. I never have said it's a pool case. And the reason that we're discussing the pool is because of the language deployed by the judge. The judge talks about the mother possibly being the mother, and the judge expressly refused to find that the mother was the perpetrator, which led me to seek in clarification, to ask in clarification on that afternoon in March whether there was a pool finding. Not because I sought it, because we had closed on the other basis, but because I was unclear about what the judge had found in by way of perpetration, the court having found infliction. So that's paragraph 49, the list. While we're at Reby, it might just be helpful to remind ourselves of another part of the legal framework, the unknown perpetrator. Paragraph 59, Authorities Bundle 77. And this is the paragraph in which Lord Justice Peter Jackson sets out the argument about whether a person could be placed in the pool of perpetrators, and talks about the burglar. If there is an unidentified or unknown perpetrator, is it possible? In my respectful submission, it is possible to deal with this issue because the judge has raised it, not because we have raised it, on the basis of the evidence rather than legal principle, although obviously both are in play, I accept. There was no evidence in this case of an other person. There is no evidence of a burglar. There is no evidence of an unknown person, even unknown but an unidentified person. The child, A, is in the primary care of mother throughout the 2 occasions of injury. The father was suspiciously saying, I'm going to visit on 1 occasion in the radiological windows, but all ruled him out as being on the list. And so on a simple factual basis, for the judge to be suggesting that there is someone else not identified is just a construct. It's not grounded in the evidence. And so before I even get to the legal principle, I say that is wrong to introduce that as a construct. And the final part of, I'm sorry, it's backwards. It's paragraph 50 of Reby, and it's the opportunity point, and that this comes from the North Yorkshire Authority. This is the section of Reby in which Lord Justice Peter Jackson is setting out the history of the pool of perpetrators. Obviously, that is the pool of perpetrators being an exception to the civil standard of proof in order to avoid the grotesque, quote-unquote, consequence of because one cannot identify who in a family has caused the injury, the child cannot be protected by care proceedings. And so the quotation I wanted to draw the court, to remind the court of, is after paragraph C in that authority on page 75. It was somewhat widened in the North Yorkshire County Council case to include people with access to the child who might have caused injury. If that was an extension, it was a principled one. But at all events, the extension does not stretch to, quotes, anyone who had even a fleeting contact with the child in circumstances in which there was the opportunity to cause injuries. Now, that is where we get to, in this case, in pre-fact-finding hearing discussions, we had raised on several occasions whether anyone else needed to be joined to intervene in the proceedings to defend themselves if someone was saying they might be a perpetrator. And we were always met with the mother's case, put straightforwardly and obviously honestly by Miss Ancliffe. The mother's case is, I don't know. The mother's case was others had come into contact with the child at the relevant time, but she noticed nothing. She was not aware. This judge has found that that is dishonest of the mother, and there is no challenge to that finding, because she must have been aware, this judge had found, because of the seriousness of the injuries and the impact on the child, even if she wasn't aware of the infliction. And so, although Miss Ancliffe and Miss Croft in their skeleton arguments are seeking to persuade this court that there was in fact a list of others, in fact there was no person intervening, because we'd had the discussions prior to the fact-finding hearing, and it was only opportunity. Those people, those other family members who Belgium and visits and other aunts and such people had an opportunity, but nothing more, and that was not a ground for intervention. So because they were not present, intervening and defending themselves because no one was asserting that there was evidence that they might have caused these injuries, the judge was left with just the 4 parties that she was left with, which is possibly why, having decided that it was not the mother who inflicted the injuries, she's left with another person, because there's no one else there. Procedurally, it would have been improper to name a family member who hadn't been there to defend themselves, and the evidence didn't suggest it either. So the judge is left only with someone else. That's the legal principles that I wanted to go to, and forgive me for, again, stating the obvious, but the point of a fact-finding hearing is to establish the jurisdictional gateway is crossed, the threshold is crossed, under Section 31 of the Children Act, so that the court can go on to consider whether to make public law orders and intervene in families. In this case, we are unclear about what the judge has found. I do submit that of all the options of the possible findings, they are all wrong. I do that with no pleasure, but they are all wrong, either in evidence or in law. And I wonder, could I remind the court of our paragraph 15 in our skeleton argument? And if the court would be assisted by having that, that's at main bundle 54. Main bundle 54, paragraph 15. In our submission, the court below has found.
I put a question mark by your 15.3.
Yes.
The mother was not the perpetrator of the injuries.
Yes.
Does she say that?
I have said that she says it at paragraph 72, appeal bundle 18, and I hope I'm... Paragraph 72, I am unable to make a positive finding that the mother herself caused the injuries. Paragraph 72. Shall I repeat that, my lord?
No.
Sorry.
I'm there as well. I mean, we've all covered this ground, you can imagine.
I'm so sorry.
So
Forgive me.
Of course, if you apply the Hoffman binary principle, if it's not 1, it's 0. So you're right in that case. It is a fact. But then how does that square with the finding, this assertion that she makes in the exchanges with you after the hearing, that she's found that the mother's a possible perpetrator?
It doesn't. It just doesn't, and it cannot sit. And the introduction of the possible perpetrator is why we're talking about pools, because that's the test.
So the question, and you repeat it somewhere else, what you said 15.3 is I would be more comfortable if you said that she was unable to make a positive finding that the mother herself caused the injuries. That is what she said.
Yes.
And to go beyond that, maybe it will be that Miss Ancliffe will support what you said, 15.3, but it doesn't seem to me that accurately, with respect, reflects what the judge said.
Well, my lord, I respectfully don't disagree, and if my wording can be improved, I'm happy to do it. But it is binary. I can't make a positive finding, and therefore it's nil, so she's not the perpetrator. And then the introduction, as my lord has alluded to, mentioned, the introduction of the lower test for the pool didn't strike us at the time, and still has not struck us as the judge making a balance of probabilities perpetrator finding.
No.
And forgive me, I may be missing the point, my lord.
No. It's just if you say broadly that there was a finding that she wasn't the perpetrator, that excludes the possibility that she was, as well as if you say she's not. If you say the judge found that she was not the perpetrator, that excludes the possibility that she was, and the judge says later on in the exchange that she wasn't excluding that possibility.
So, my lord, we mentioned this in our skeleton. This has not survived the written transcript. The judge announced that decision orally at the start of her judgment. I am not finding it's the mother. The whole judgment in my submission is structured around that, not what is the local authority's case.
So at the outset of the hearing, I was going to ask you, at the outset of the giving the judgment, she announced her decision.
It's not on the transcript, because my lord will remember that it took us 3 months to obtain this transcript, and the judge had said to me, on that Friday evening, achieve the transcript, and I'll take on board your points.
At what point, forgive me for...
No.
Where in the judgment did she say it? Literally, the first thing she said.
Not the first thing. I would say we haven't chased this down, my lord. We haven't asked for the tape because it didn't seem to us to be terribly important.
At an early point.
At a very early point. And it was at that point we were all, well, I don't speak for others.
And, forgive me, what exactly did she say? I am not...
Having just had the exchange with my lord, I wouldn't like to say whether it's I am not making a perpetrator finding or I'm unable on the language. I wouldn't like to say from memory. But she was...
Words to the... I'm making a note here. Words to the effect of...
It's not the mother.
It's not the mother.
So there we were, my lord, waiting for the explanation of why we'd all got it wrong and it was a pool. And we get to the end of the judgment and there's no pool. And I stand up and say, well, what's the pool? Oh, there is no pool, I'm told. So there's no perpetrator and no pool, but inflicted. And that none of that sits. That's just wrong.
Well...
I said no. My lord, Miss Pickles might have the wording if it would assist. If, my lord, having asked, I said no to Miss Pickles, but... please. So at the very start of Miss Pickos's note, and I'm sorry we haven't chased this down, we haven't agreed this note, but the very start of Miss Pickos's note, if mother did not cause them, then she should have known who caused them. So there's an if.
Again, sorry.
That's different.
Say that again.
If mother did not cause them, this is a note, cause the injuries, then she should have known who caused them.
She should have known.
Now, the only...
That's
well,
a conditional sentence.
Yes. So the only part of the transcript that I could see that was different from the oral judgment I received was that taken out from the start. But I haven't sought to chase that down properly because it seemed to me to be a potential tangent from the core of the appeal, which is whatever this judge has found, it's wrong. My lord, in my respectful submission, my lady, in my respectful submission, the court having found inflicted injury, it is incumbent on the court to deal with perpetration of that injury. That is why we have fact findings, hearings. That is part of the Section 31 test, the attributability point. Who is it attributable to? And this judge didn't find perpetration except on one reading, possibly mother or someone else. And that in our interpretation of that is mother in a pool with an unknown person, which isn't grounded in any evidence. There is no evidence that there was another person involved. And on either of those analyses, both are wrong. And neither meet the Section 31 threshold test, the point of the fact finding in the first place. Neither meet the attributability point.
Just so that I'm clear on two things. First of all, from what you're just saying, therefore, in the circumstances, can't find on the balance of probabilities that it's mother, but have found inflicted injury. In those circumstances, pathway left open for a judge is not to assume there is a burglar, a hypothetical person, but in those circumstances to look carefully, as what you're saying, I think, back at a conclusion that you couldn't find on the balance of probabilities, because otherwise you're left with on the lower test, a pool of one. And you can't have a pool of one. So that should ring a bell in a judge's mind that perhaps they should need to go back and look at the first question and whether they've answered it properly. That is what you're saying.
Exactly so, my lady.
Just
Can I
to
ask?
put in simple simple terms.
I'm very grateful. Can I add one other point to that? And it's our compartmentalisation point. When a judge hears, or in this case reads, the medical evidence, and then hears the lay evidence properly over 5 days, and the judge goes off to put it all together, in making the infliction finding based on the medical evidence, the judge must know that that will require a perpetrator finding. And in putting it all together and considering it all, together as opposed to in a linear compartmentalised way, the judge should have considered all that. Now, there's a limit to that submission because the judge is right on this medical evidence and no one is challenging it that it's inflicted. But a very great deal flows from that finding of infliction. My lady is probably repeating myself. My lady has accurately summarised my point, which is...
Does this not leave a judge in these kinds of cases in a difficult situation? Because medical evidence shows, and you find and hold from that the injury was inflicted, but you're only offered one person by the parties before you, but you don't think actually on the balance of probabilities the evidence stacks up against that person, but there is no pool. So is one driven in any event, and this is perhaps the situation of the judge here, perhaps not, driven to a conclusion that actually on the evidence you don't think is right, although the second stage is at a lower level.
So one of the odd things about this hearing is that we didn't have the oral live medical evidence, and there's no criticism of anyone for that, but we didn't have the live medical evidence. And sometimes there are doubts raised in cross-examination about the medical evidence on timings or on mechanism, but this judge was left with these written papers and had no wriggle room, can I use a colloquialism, on the medical evidence. And so when the judge retires and puts together the positive broad canvas that, can I say in passing on behalf of the children we were asserting, the positive broad canvas evidence, the gentle and loving mother in all other circumstances, but this overwhelming medical evidence of infliction on more than one occasion, she should have put together that and known that if she was finding infliction, she had to deal with perpetration properly. It is driven, my lady has just used the word driven, it is the court being driven against the social evidence of a loving mother, driven by that medical evidence to someone has done this and there's no one else. And it's a very obvious conclusion. And it's a common dynamic and a common scenario in courts hearing fact-finding hearings, putting that often good social evidence together with very clear medical evidence. And it's why, one of the reasons I suspect why we often frame it in the terms of a very good loving mother, perhaps stressed, perhaps tired, momentary loss of control. There's no deliberate desire to harm children usually. Very rarely is there a deliberate evidence of deliberate. It's a loss of control and a snap, albeit here on at least 2 occasions. So yes, my lady, I'm praying in aid. My lady's word driven.
Thank you. I'm sorry to have taken you away down a slight cul-de-sac.
Not at all.
Can I just also confirm what you're saying about what the judge said? I know we've been over it.
Yes.
But she is saying at 72 of the judgment, I'm unable to make a positive finding that the mother herself caused the injuries. And then at 73, I do make a finding that the mother knows how the injuries were caused and has chosen not to tell the truth. And you are saying that at the very beginning of the note that very helpfully was read out, if the mother did not cause them, then she should have known who did, which is slightly different. So can I just be clear about precisely what your submission is in relation to those 2 paragraphs and what you read out from the note?
So, my lady, my submission, I'm sorry to put this so bluntly, but my submission is that I don't understand this judgment.
Okay.
And so that's why we sought clarification, immediately orally and then in writing. I simply don't understand it, and it doesn't sit with itself when one puts those, we've listed them in paragraph 15 of our skeleton, when one puts the statements of the judge, they are contradictory.
Well, is it would it be helpful to look at what she said? Are you coming to look at what she said in the exchanges afterwards?
Yes.
Because it seems to me that there are some very clear clues about what she thought she was doing.
Yes.
So on, and I've obviously we could read it all, but in response to you at the bottom of page 23.
Yes.
Your Honour has not said pool, you say. Judge says, I know that's because no pool was identified.
Yes.
True.
Yes.
You say, so that's deliberate. She says, yes, yes, yes. Might we just think about that? You say that silken way. And then she says, I mean, it only makes sense, does it not, if you have a list. Otherwise, it is mother or someone else and mother knows. I suppose it is a pool, but without anyone else to go in it. I do not think it matters very much, in that I do not think, unless you tell me I'm wrong, I do not think your concern is about what finding I have made. And then she makes a point about the father. So at that point, she is saying, I suppose it is a pool.
Of one.
Without anyone else identified to go in it.
Yes.
I don't know whether you then say you can't have a pool of one. Maybe you do.
My lord, can I just pick up on a point? There's nothing silky about this exchange. It's a mortifying transcript. But I say to the judge, it's problematic. This is problematic because you found threshold. I'm going to come on to what I think the judge thinks she's found by way of threshold, and it isn't a threshold finding, what she's found, because it's dishonesty. But I digress, forgive me. At the top of the next page, I do think that is problematic.
You asked for 10 minutes.
We asked for 10 minutes.
Now, the next bit I've underlined is, I've 24, 25 may contain more archaeology, but I've underlined the bottom of 25. She asks you, what is wrong with the fact that mother either inflicted it or knows who did? That is an echo, sort of echo, of what she said at the start of the judgment, but is now excluded, deleted.
Yes.
And then top of 26. You see, I'm quite clear about what I actually found.
Yes.
Yes, which is that the mother either inflicted or knows who did. So there, she is definitely saying, and she says it again, that the mother is a possible perpetrator. I'm clear about, and I'm comfortable. Why do I then need to say, and there is a pool of identified people? It seems to be very artificial. Okay, and then more exchanges. At the bottom of the page, she says, I have not been able to identify the perpetrator. I made it find that if the mother did not cause injury herself, she knows how they were caused and has failed to tell the truth to the court. That was certainly meant to include the possibility of the mother as a perpetrator. And again, similar at the end of my judgment, that is what I was intended to do.
Possibility.
So she says so 3 times, that she was in 3 or 4 times, that her finding was the mother was a possible perpetrator.
Possible, yes. Full of one, yes.
Well, a possible perpetrator in a pool. That's the second point. She doesn't find. So when you say, going back to 15.3, that finds the mother was not the perpetrator, she finds the mother was a possible perpetrator.
Well, my lord, except that we then have email exchanges, and the judge emphasises in those email exchanges that it's 72 and 73 of the main judgment.
I know.
And so I don't know what to do with this court, with that exchange. Because the judge, in clarification after that exchange, after we'd achieved the transcript, says, I'm not saying anything more, it's 72 and 73.
Yeah.
And 72 is the one I've read out, unable to make a finding that mother's the
Judge doesn't say, in those exchanges, I mean, it's clarification by email, which, as you know, is not something
No.
this court approves of.
No.
But she doesn't retract what she said, which is that the mother was a possible perpetrator. She doesn't retract what she said 3 times in answer to you. She refuses to go beyond 72 and 73.
Yes. And I think Miss Antliffe's point in her skeleton is we can concentrate on 72 and 73 and it's quite clear what the judge has found, when it just isn't, my respectful submission, because of those exchanges. And in fact, in final preparation for this appeal, I have wondered whether there is in fact one ground, and that is we don't know what the findings are. Without getting into pools, and we just don't know. I haven't said that. In my defence, there was a bit of a scramble when the local authority announced they weren't appealing and we had no legal aid. I'm going to leave that irritation to one side. But that's a fact. But I don't know what the findings are, and we have not attempted or successfully attempted to put into writing, as we should, on an order, because Miss Ancliffe, on behalf of the mother, is never going to agree, I am guessing, and from her skeleton it's obvious, is never going to agree that there is a finding that the mother is a perpetrator, or even a possible perpetrator. So, and on this written documentation, Miss Ancliffe's right. I wouldn't either. But that is deeply unsatisfactory for these children, deeply unsatisfactory for the future of these proceedings. What is the narrative for these children? How do we assess? And that brings me to what the judge purports to have said about threshold, which is the threshold is crossed on the basis of mum knowing but not being honest about it. Well, what's the harm? These are deep and murky waters if the threshold is crossed because of dishonesty.
Infer that it's a likelihood finding. But she's finding that because of the mother's, and this is the way Miss Ancliffe would seek to persuade us that the judge found the threshold was crossed. I mean, I may be wrong, but my guess is that the point is that the judge, because the mother on the judge's finding knew what had happened but hadn't disclosed it, that she was acting in a way which was contrary to the child's welfare, and there was a risk she would do it again. So therefore, a likelihood of future harm.
Without any evidence, because on the basis that the mother is not the perpetrator, and you can't have a possible perpetrator, because that's a pull of one, on the basis of what evidence does that meet the threshold? Who is around on this mother's evidence? Who is around to cause future likely injury? Because it's not the mother on that finding. And that's a deeply problematic position for a final threshold in terms of informing the risk and informing the welfare analysis for part two.
Well, Miss Ancliffe would argue, I anticipate, that, maybe it's not for me to anticipate, but I think what she will say is that the judge has excluded the mother as a perpetrator. And the mother is only culpable for failing to disclose what she knows.
Yes.
And that's a less serious form of parental culpability than the sort for which you were arguing. Much less serious. Miss Ancliffe would say.
And respectfully to Miss Ancliffe, I have some sympathy with that submission on the basis of this material. It's just that it's not acceptable as a position. On the law, I respectfully suggest and submit to this court. Because to go from these very serious injuries, certainly beyond the significant harm threshold, to dishonesty, mother isn't telling us as the risk assessment for part two, leaving aside for a moment about getting it right at fact-finding, but informing part two and risk assessment. What's the risk? Is the risk dishonesty or hiding evidence, not injury? What a completely artificial construct for the future of these children, my clients. Completely artificial and a concoction. And it's not... Another thing I can't assist this court with is why. All I can say to the court is I assume that the judge has said the broad canvas here is so positive that I cannot be driven, despite the medical evidence that I've accepted, to the conclusion of perpetration by the mother.
Well, we could speculate.
We could speculate.
But we shouldn't. I mean,
I agree.
There are some obvious avenues of speculation which I think we should avoid.
I agree. I'm grateful, and I do agree. My lord, my ladies, I'm just checking my note because I think I've dealt with what is the judgment of the court below. I hope I've dealt with paragraph 15 properly. I'm very confident that the court has the points, they having been read back to me, the points in our paragraph 15 about the contradictions in the judgment. We say that there are obvious contradictions that do not amount to meeting the evidence and the justice of this case. We say that there is an absence of clarity and we say that it is wrong in principle. And fundamentally, we say that having found inflicted, it is incumbent on the court to go further and decide perpetration, or explain carefully why perpetration cannot be found. And I, in preparing this appeal, have not been able to think of a factual scenario in which a child of this age does not have a list of perpetrators. It's the carers, often two carers, in this case one carer. There's always someone on that list because of the age of the child. The child isn't independently living. And in this case, it happens to be one. The judge did not go through the exercise of the list and seems to have dismissed the list in that exchange with me. It doesn't make any sense because we don't have a list. Well, she didn't stop and ask herself, what is the importance of not having a list, the list being one? And didn't go through that re-be exercise in the order Lord Justice Peter Jackson set out. And so I am less clear about the submission that it can never be right to find inflicted without a perpetrator. I am very clear that our submission is in these circumstances, it's wrong. If this court wants to go further and say, you can never do that, all I have for this court at this stage, and I hope it's helpful, is that I can't think of a scenario where a child of this age doesn't have at least one person on the list, as here. And so this is very, under the legal framework as it's well understood, this is actually very straightforward, in my respectful submission. I hope that isn't a hostage to fortune. Can I just turn my back? I think I've probably at this...
What are you going to ask us to do if we're with you?
Thank you. Unusually, this is a case where this court, because of the parameters of the arguments, can substitute the finding. And that is because inflicted isn't challenged, dishonesty isn't challenged, the absence of any other named individual or even a witnessed unnamed individual on the list. It's a list of one. And so it's an obvious perpetrator finding. And this court can do that. On behalf of the children, the delay of...
Well, I appreciate that, but isn't there a... For my part, I'm troubled. I'm just trying to think, articulate why I'm troubled by that course. This is a case where the judge, having focused very clearly on the parent's evidence, the mother's evidence, was not persuaded that it was the mother. Was not persuaded to make the finding.
Yes.
But in those circumstances, it feels I'm at the moment uneasy about this court overturning that.
So the context of the judge not being persuaded that it was the mother, I won't go on about the list. I won't make more submissions about the list. Has to be seen in the context of also finding that the mother is hiding evidence, unchallenged finding, that the mother is hiding evidence and is aware of very serious injuries and didn't get medical attention notwithstanding that awareness and isn't telling us the truth. Now, I understand, my lord, my lady, my ladies, my lord, that the submission that this court can substitute is perhaps a rare and unusually not often successful. And I understand. I understand the process. But we waited 3 months for this transcript. We're now in September. It's 6 months since this fact-finding hearing. There's young children.
Yes.
And an obvious outcome, more importantly. An obvious outcome. On the parameters as expressed properly by Miss Ancliffe. Inflicted, no response notice, no challenge to inflicted and no challenge to dishonesty.
Well, is the local authority's plan at the moment, if the appeal is allowed, is the local authority looking at permanent placement outside the family?
We're at the stage of identifying assessment for part 2, and that's on hold.
Okay.
And Mr. Toomey will be able to help more with that. Another
reason why I'm troubled is that the judge, about what you say, is the way the judge stuck to her guns on her finding.
Yes.
And wouldn't there at least be a reasonable chance that a rehearing would uncover things which the judge knew was there, but she'd not been able to discern?
Well, my lord, having having lived through the mother's evidence, unless it changes, I can't see it myself, and my submission is that no. But I understand that there's a process point here and a fairness point. On behalf of these children, I'm not trying to adopt an unfair process. But this is such a wrong judgment, and on this evidence, such an obvious outcome, that I ask the court to consider the substitution. The other point, it's obvious on our skeleton. The other point I just want to make, and my Lord's last comment has reminded me of it, our ground, that none of this was discussed. This was closing submissions. It was late on a Friday afternoon. We all have sympathy with hard-working judges, and this is a hard-working judge. We all have sympathy with hard-working judges on a Friday afternoon.
In the busiest court in the country.
In the busiest court in the country. And there is no pleasure in us bringing from that court this appeal. No. But it is, I'll say surprising. It is surprising that with either Miss Watson or myself, the judge did not trail this outcome in either the evidence or in submissions. I submitted that there was no one else on the list. The medical evidence was overwhelming, and sat down, thinking that was it. And then the judge didn't come back at me and say, what about other people in the pool? What about other identified? Or we would have said all this.
But this just, in a sense, underlines and reinforces my anxieties, I think, because this very experienced and highly regarded judge was clearly troubled by big gaps in the evidence, my phrase, not hers. And that's what led her, it seems to me, to this unusual finding. And if that's right, would not a rehearing provide an opportunity to explore that?
Well, of course it would.
And I don't want to spell it out, Mr. Turin, but there are obvious lines of inquiry.
Of course it would.
Further focus.
My Lord, and the problem with my response to this is that I'm probably in trial lawyer mode and not appeal lawyer mode. But having lived through the trial, I cannot see it on this mother's evidence. It is, I do not know. And mother sticking to her guns, I do not know, I'm not aware. I just don't know. And with nothing to shift. No, but of course, a further process might throw something up. And of course, on behalf of my clients, if it did, I wouldn't want to avoid that. But at this stage, and having read Miss Ancliffe's skeleton argument, I hope carefully, I see no change in the mother's evidence or position. But that is, I am making assumptions, and I take the process point.
So the children, are they placed separately? The older children in one placement and the younger child?
Yes.
And are they all in foster care?
I understood that the older children are with a maternal aunt, and the younger child is with a paternal grandmother.
Right.
Thank you.
Okay.
Might I just turn my back? I think I've probably said everything I wanted to say in presentation.
May I just ask you one question?
Yes, of course.
I think as a result of those exchanges, you seem to be accepting, Mr. Turin, that this court would not be compelled to substitute.
Certainly not.
No.
It's a discretion.
Yeah.
Certainly not.
But you're not saying this is such a strong case that the court would be compelled on the facts to substitute?
Not compelled, because, and I respectfully accept the process point that rehearing it may throw something else up.
All right, that's really
and I accept that.
All right, thank you.
Can I assist further?
Thank you very much indeed. Mr. Toomey?
Thank you. My lady, my lord, the local authority supports this appeal. Could I start perhaps with the way in which the local authority framed the case, because that has come in for some criticism. It is made clear in the local authority's threshold statement of facts, pages 5 to 6 in supplementary bundle, that the mother was the alleged perpetrator. No other party was alleged to have perpetrated these injuries. In the opening note, the position is made plain, again at paragraph 7, page 36, the mother is the perpetrator. And it's right to say, is it not, that on reading the judgment, there is very little consideration, and certainly no discussion or analysis of what the mother says in her own statements about where she stayed, with whom, and the periods of time that her baby spent, brief periods of time, basically the baby spent with other family members. And so, in the light of all of that, do we not start with Justice Peter Jackson's analysis in Re B? In fact, at paragraph 46, which electronically I think is 74 in the authority bundle. And this echoes my friend Mr. Tuan's point, which is to state the obvious, the middle of that paragraph. So, to state the obvious, the concept of the pool does not arise at all in the normal run of cases, where the relevant allegation can be proved to the civil standard against an individual or individuals in the normal way, nor does it arise where only one person could possibly be responsible. In that event, the allegation is either proved or it is not. There's no room for finding on the basis of real possibility, still less on the basis of suspicion. No such thing as a pool of one. That was the background to the case. Nobody considered that this was a pool case, as I understand it, at the start. And it may be the judge thought it was, as her post-judgment comments suggest. But nobody thought that. And these matters were considered carefully. So my lord will see that, I think it was on behalf of the children, that a recital was extracted in the order of the case management order in February, which we have in the supplementary bundle, the 13th of February, page 64, the order appears. And the relevant recital appears at the bottom of page 65. And this was a recital sought by Mr. Tuan on behalf of the children. Which concludes at the top of 66, in relation to those siblings, no party seeks to explore that issue, that is, that they might have been responsible, nor will make final submissions on that basis. So the possible alternatives of the siblings, older siblings, was ruled out by agreement. And that, in substance, fits with everything else the mother said about other family members, because her case before the court was, both in written and oral form, that although she left her baby with family members briefly, at no point did she see or hear anything that was troubling. And given the evidence of the experts, she would have heard or seen something subsequently that was troubling. So, in respect of the possibility of an alternative perpetrator, the mother's case is an admission against her interest, is it not? It's a case that no other primary carer, no other carer could have done this. And so it follows that the court should attach great weight. One aware, of course, that people can retract an admission or seek to go back on the admission. But her case was that this must have been some sort of accident, some sort of hidden accident that she didn't know about. And so the case was initially, I think, listed for 3 weeks. And the concern that gave rise to that lengthy listing was that it might have been the case the mother would have brought in the relatives in Belgium, relatives in England, the very many relatives that she had seen in the course of the window of opportunity for causing injuries. But in fact, as we know, it didn't require any of those witnesses. And the mother very clearly saying that there was nothing suspicious arising post the brief periods of time family members had with the baby. So that's the factual background. I think the first question really is, what did the judge find? And did she find a pool? The Lord Justice Baker has already identified, I suggest, the relevant passages in the post-judgment discussions about that. I suppose the question is, if one turns to paragraph 73, where the judge says, I do make a finding that the mother knows how the injuries were caused and has chosen not to tell the truth. Are there not two subsets? She knows because she is the perpetrator, or she knows because she was a witness and she's saying nothing. So in fact, that's not inconsistent with what she said post-judgment in discussions. What she has done is she's dropped out the rather important point that it could have been the mother. But on the first sentence of paragraph 73, one is left wondering whether the judge, consistent to her post-judgment discussion, was saying that she knows because either she did it or she saw what happened. And of course the difficulty is that despite attempts at clarification, we don't know. And one is left also with the suspicion that, or the belief, that the judge has in mind a third party, but is not telling us. And that's simply not acceptable. At the end of a lengthy inquiry, not just the week's trial, but that which leads up to it, it is disturbing that though a child has suffered potentially life-changing injuries, we don't know who has caused them or who might have caused them. And so, in my submission, it is quite possible that the judge, in the exchange with the letter from Mr. Tuan, said on occasions, why does it matter? Why does it matter for me to, for example, have the mother and another, or others? Why does it matter? And the answer to that is surely it matters to satisfy two things. The attributability, that is that the care provided was deficient, it caused significant harm, the gateway to section 31 is opened on that basis. And two, moving forward to welfare, the risk assessment is carried out on the basis of that finding. But what we're left with is the finding at paragraph 73, which is a finding that the mother knows what happened but isn't saying. Now that is not a finding as to perpetration. And that's why I wonder if it's even a threshold finding. I have to accept it might be well said to be a threshold finding, because if you know that your child has been seriously injured and you say nothing about it, about how it happened, in the course of care proceedings, and your children are removed from your care, when they shouldn't otherwise be, if you've been straightforward about it. I mean, if these were two accidents or two burglars on separate occasions causing injury and you can identify what happened, you must say so, because otherwise your children are taken away and they suffer harm as a result. So I can see that the care planning has been infringed by the mother's failure to tell the truth. But it's not a finding that she's done anything wrong in relation to the perpetration. Neither that she did it, nor that she might have done it, unless this is a full finding. So, in our submission, the court really hasn't grappled with what finding it's made in respect of threshold. If one looks at the order, it simply says threshold is found on the basis of the judgment. And the judgment concludes, paragraph 73, the threshold criteria are met on that basis. So that is, of course, deeply unsatisfactory. The primary problem, therefore, is that what is the risk assessment going forward if this judgment stands? What is the mother found to have done that she should not have done? And what she has not been found to have done is that she's not been found to have failed to protect the child. And that's important because there were two incidents separated in time. So if the judge finds that, to take the mother's case, that paragraph 73 effectively acquits the mother. I mean, we've said in our skeleton that we think it's a finding. It's a finding that the mother perpetrated the injuries rather than the finding that she did not perpetrate the injuries. It may not matter. But if the mother's right about that, then what is the risk that she presents? the risk she presents is that she's not always going to tell the truth when something dramatic happens to her children. That's a very different risk to a risk that she might perpetrate potentially life-threatening injuries to her baby. So in relation to the pool, we think the learned judge may well have had she must have had it. She had a pool in mind. And the first sentence is not necessarily inconsistent with the pool. And I think it is important, we would submit, it is important that the judge at no point when she refines her judgment says, I've changed my mind. There are those cases. But what she says in the email exchange is, I remember what we said post-judgment, and I've taken that into account. I'm happy with 72 and 73. So one has to assume that 72 and 73 are consistent with the post-judgment exchanges. And at the very least, that's a pool finding.
Yes, I mean, the judge declines to accept that in the email exchanges, doesn't she?
She does. I mean, I suppose what she might say, accepting the problems with emails to judges about these things, but what she might say is actually you gave me a very limited option. So if I find the email exchange, I think we can see that, thank you, she was page 32. And then at 34, I want to clarify, and the first option is, have you found the mother is in a pool of perpetrators consisting of the mother and an unnamed person who's known to the mother, and the mother's lied to the court? Well, I suppose she might have found a pool consisting of the mother and more than one unnamed person known to the mother, or an unnamed person not known to the mother. And of course, she doesn't clarify. And the second option, whether your finding is that the mother did not cause the injuries, but knows who did, and has lied to the court about it. Well, I respectfully suggest the fact she doesn't agree with that means that she's not ruling that out, which is consistent with her post-judgment exchanges, that it was either the mother who did it, or she knows who did it, and not inconsistent with paragraph 72 and 73, where she says the mother knows who did it, but doesn't add that detail about it potentially being the mother. The known judge's response is simply to say you're wrong about either of those, and that may be why. But it is difficult to take it any further than that. So in this case, what we say the judge should have done is she should, at some point in her judgment, set out, if she had taken the lead from the parties and the evidence, there'd be absolutely no evidence of an alternative perpetrator. She should have treated this case as a sole perpetrator case, and she should then have set out all the evidence pointing towards the mother as the perpetrator and all the evidence pointing away from her as the perpetrator. And our submission is that at no point in the judgment do we see the judge do that. At no point in the judgment does she identify, in fact, any evidence as pointing towards perpetration. She deals with lies and says, well, that's not good, but they don't point towards perpetration. In fact, the analysis of the mother as the potential perpetrator in this judgment recently is confined to paragraphs 72 and 73, so those 10 lines in the judgment, because there she deals with perpetrator, and all she says there, she's taking into account all the positives surrounding evidence, and curiously, the fact the mother hasn't given a full picture is a pointer towards the mother not being able to identify the mother, when a failure to provide a full picture is often a pointer towards perpetration. That is it. Paragraph 72, those 5 lines, is the analysis of the case against the mother. So what should she have done? She, we say, should have considered that, consequent upon her finding that these were at least 2 sets of injuries, she should have spelt out the fact that that meant that her baby sustained serious injuries, sustained rib fractures and a brain injury, that she knew about it, and she did not seek medical attention for it. A delay or a failure to seek medical attention is routinely, for obvious reasons, a pointer towards perpetration. At no point in the judgment does she identify that pointer. Secondly, she, consequent upon her findings, should have identified the fact that this meant that the mother had lied about the child demonstrating no sequelae. No, there'd be no signs of injury.
She found that? You say she did find that? Or should have found that?
She should have found. Because if the child was effectively, as she finds, assaulted and suffered these injuries, and she accepted the medical evidence, the mother saying there was no sign of anything, it must follow that the mother lied about that. And that, again, is a pointer towards perpetration.
Well, she does find in paragraph 69, I find it inconceivable that the mother could have failed to notice the swelling over such a lengthy period, and at 70, again, it's highly unlikely that an attuned primary carer, as this mother is, would have missed signs that her child was behaving unusually because of the extent of the first injury, etc. So she does at least point to that.
Well, she doesn't, I think.
But you say she didn't join up the dots.
No, exactly. I mean, that,
Yeah.
and this all follows on from her finding that these are perpetrated injuries. She only identifies, in fact, exculpatory evidence. That's at 64 and 65. That's the discussion of the wider canvas and the mother's good care. So where she comments on the evidence as pointing either towards or in favour of perpetration, she only, in fact, comments on positive evidence. So standing back, she should have taken account of the fact that 3 sets of injuries, serious injuries, occurred in the mother's primary care. The mother hadn't identified an alternative perpetrator, which is an admission against her interests. There was no evidence, there may be some suspicion, speculation, but no evidence upon which the court could conclude there was even a real possibility of an alternative perpetrator. And so this wasn't a case of the mother and mere opportunity, but one might say the mother and sole opportunity. She doesn't rely on the fact the mother demonstrated little curiosity about how the injuries were caused. That might be a pointer to, that's paragraph 34, and that might be a pointer towards perpetration. She doesn't say the mother taking issue with the doctors at paragraph 34, again, was a pointer towards perpetration. She doesn't rely on the fact the mother had held back from a full and truthful account. As I say, in paragraph 72, she relies upon it as a pointer away from perpetration, because it's a smokescreen of uncertainty, when in fact she should have looked at that and relied upon it as a pointer towards perpetration. And so ultimately she should have found that the mother lied about not knowing how the injuries to the ribs were caused, the injuries to the brain was caused, how the fractured skull was caused. Unless, nowhere does she deal with the potential for failure to protect. There's no finding of failure to protect. The only way in which, on the facts of this case, careful to say the only way, but the only way I can think that there may be no failure to protect is if the first and second sets of injuries are wholly unconnected the perpetrator of set 1 is unconnected to set 2, and they were both unforeseeable assaults. Seems quite unlikely, but that again should have been considered by the judge. And then I think in relation to third parties, of course, the judge had a very clear chronology as to where everybody was at different times. And I think the judge's finding is that the mother, in fact, noticed the swelling on the 31st of May, as she told the hospital, even though the mother had lied about that. Well, the 31st of May, if that was the first swelling, then clearly the skull fracture could not have been caused in the care of the aunt M or any of her children. It could have been caused in Belgium, but the people in Belgium couldn't have caused the earlier injuries. So again, she would have to think about that. So I think what it leads to potentially is when Milady, Justice Asplin, asks the question about the judge saying to themselves, I've got a very attractive parent who has done many good things and clearly has excellent parenting skills in many respects, and there are many good things to be said about that parent, but I just can't believe that he or she could have done this. Then what I suggest is that certainly in the first instance, that might be a pointer away from, despite everything the experts say, from this being inflicted. So at that early stage, you've got all the experts saying this could only be inflicted. You've got a blameless, apparently blameless parent or parents, and there are those cases where the expert evidence all points towards perpetration, but the judge says, no, I believe the parent. But if, having come to the conclusion, as this judge has done, in a way that is beyond criticism, that these were perpetrated, 3 sets of injuries on at least two separate occasions, then she has to ask herself, first and foremost, the only person identified as a possible perpetrator must be the perpetrator.
The difficulty with the finding that the injuries weren't inflicted, contrary to the medical evidence, is that no mechanism was put forward in the mother's evidence to explain how the injuries happened.
Yes, well, exactly, and they're different sorts of injuries.
Yeah, so you might have a case in which the medical evidence concurs that the injuries were inflicted, but the judge is convinced by an explanation about the mechanism for each injury and rejects the medical evidence in that way.
Yes, I mean, and there are cases where no one can actually come up with a mechanism and just unknown cause.
But you say this isn't that case.
Well, it's certainly, well, it's not, because the judge found they were perpetrated. Yeah. So that's why we do say that this court, if it allows the appeal, can substitute a finding. And may I just deal with, perhaps I should just finish in relation to the submissions on the appeal. Just check my instructions. No. Thank you. So in relation to the grounds of appeal, which we support in writing and now orally, I don't know if there are any other submissions I can assist with on that, and otherwise I'll deal with the remedy that...
Yes, disposal.
So for the reason I've set out, there is only one, on the evidence, one possible perpetrator. And given the simple balance of probabilities test, the perpetrator must be the mother. And in those circumstances, on the judge's otherwise unchallenged findings, there can be no logical alternative. There is a second chance for the mother. She can respond to the judgment. She will be assessed. This is all assuming the appeal were allowed, but she would be assessed. And in the course of the risk assessment, parents often do reflect and say, well, there is something I didn't say. And that might then open the door to further inquiry, and that does happen. But if the question for this court is, looking at it now, is there any prospect, any good reason to order a retrial in the light of the overwhelming evidence of one perpetrator and the case against that person? The answer must be no. The mother has held hard to her case, not going to shift. There was clarity in respect of the siblings, there was clarity in respect of the relatives. If the mother's case were right, for instance, that the local authority failed to, as it were, open a berth for an unknown perpetrator, well then would not every case require a local authority to so plead it in that way? And would not every case then involve Uncle Tom, Uncle Dick and Uncle Harry coming to court even though there was no evidence against them, save that they briefly had care of the child unsupervised in the window of opportunity? And that cannot be right. So there is it's not, the door doesn't close at this point. This is the threshold point, and the finding against the mother, the court is obliged to keep its mind open. And if something occurs, as are those assessing, and if something comes up, then it'll have to be investigated in whichever way the something requires. So for those reasons, and in particularly given the extent of the delay for these children, accepting it's a discretionary remedy, we say it's such an overwhelming case, nothing will change. This court should do, I think ultimately I would say, what Mr. Justice Hayden has asked or has suggested judges at first instance need to do, and we refer to this in the skeleton argument.
Again,
so page in the bundle 193, our paragraph 18, we set out the relevant paragraph from a case called Lancashire County Council and N. It also requires to be stressed, in my judgment, that identifying a perpetrator on the balance of probabilities is a duty imposed upon the judge, where the facts permit. And the court can go on to read the rest of that passage. There is sometimes a disquiet that parents are included in a pool, knowing that one of them must be innocent, for the greater benefit of child protection. There's an equal requirement to discharge these cases and determine them on the simple balance of probabilities. And in my submission, on the face of the evidence in this case, and the facts found by the judge, the otherwise untarnished facts found by the judge, I submit the obligation is a firm one if it causes no unfairness for this court to substitute a finding of perpetration. Can I assist my lady, my Lord Hay?
Thank you very much. Thank you.
My lady, my lord. May I begin on behalf of the mother with the note that this judge, as my lord has acknowledged, is a highly experienced judge who had case managed this matter throughout, was familiar with the case, had conscientiously, in our submission, considered how this case should proceed, and had determined, because of the way the case was presented to her by the local authority, of course the onus being on the local authority to put a case and to identify what it is they invite the court to determine, considered very carefully the evidence. In our submission, she was not only conscientious, but she was careful to be fair, not just fair to the mother, but all of the parties in her consideration of the case, but was driven in her conclusion to reach a view, and that view she stuck with. And that, in our submission, is very, very important. And I will come to the second discussion, or the discussion that took place in a moment. But ultimately, in our submission, the judgment is finally formulated and perfected by the judge, and her decision in that judgment is the judgment that is being challenged before this court, because opportunity was given for her to vary it, change it, amend it, add to it, albeit we will submit, and I'll expand if I may in a moment on this, in a limited way. That is the judgment of Her Honour. Of course, the starting point in any case is what is it that the local authority invites the court to do? What is the case that's presented? And my Lord very properly invited Mr. Chewan earlier on to identify what it was that the local authority put, and my Lord has that document, not in its formulation by the local authority, but it differs not because it's the mother's response to that document, and it appears in the supplemental bundle 1 to 6, and it is very clear how the local authority sought to put its case and establish its case. And Lord has within that the clarity that the local authority express in their document, that it is only the mother that they seek findings against in the way that they put the case of her being either the perpetrator or being negligent as to the care of the child. And so there was a very clear position on entering this case. And indeed, of course, my Lord is aware, because you've just been taken to the draft order, the finalised order, forgive me, of an earlier hearing where the mother was effectively, if I may use the colloquialism, asked to pin her colours to the mast as to whether she was making accusations against anyone. And she was clear that she wasn't. And at no point, my Lord, and unusually in this case, and my Lord, my Lady may note that in the judgment, Her Honour comments upon this, because there are many opportunities in this particular case on the facts where the mother could have sought to place blame elsewhere. Repeated opportunities, but that wasn't the case that she put. And we, on her behalf, bound by our clear instructions, were therefore never going to seek to put a case that it was either child X or child Y or a cousin, because those weren't her instructions. All she was able to say was, I didn't do this, it wasn't me, I don't know how it happened because I wasn't there, I accept the medical evidence that there has been a serious injury to my child, and so far as that injury is concerned, I cannot say how it happened. I can speculate that there may have been an accident in my absence, and my Lord, my Lady, I will take you to, if I may, just so that there can be a little more clarity about the case that was being put over time on behalf of the mother, and the mother's statements appear in the supplemental bundle. I note that my Lord, my Lady read the documents carefully, but in particular, for example, paragraph 19 of the supplemental bundle, internal page 11, electronic 12, paragraph 19 sets out fairly fully, without referencing any of the parties, the first person referred to there is the aunt, and the period identified is April 23 to the 24th of May. Of course, that is the window, and indeed one sees there a reference to the mother making quite clear, we're not talking about moments here, that she would sometimes take a nap for an hour or so, and the child being left in the care of others. And so, of course, this case has been presented on the basis that there were just brief moments where the child was in the care of any other. In our submission, that isn't quite the analysis when one looks at this statement. This statement is August 2023, where the mother can't say, look, something happened, but is making it quite clear that others were caring for her child at 4 periods. And I raise that, Lord, because, of course, procedural fairness requires a local authority to consider very carefully statements filed by parents, even if that parent is reluctant in any shape or form, as indeed this mother was, to suggest that something else may have happened, or that someone else in the family could have caused an injury. And this mother was very clear throughout. She was never going to point the finger at anyone else, and that she didn't know anything. But the procedural fairness point would require a local authority reading this statement to give a broader consideration to what this case is about, and to consider what ultimately ended up in a tangle at the end of the case, because, of course, the judge was reading these statements as well and considering all the facts as to whether something else may emerge as a conclusion in the fact find. So, of course, even though they pleaded it in that way, in our submission, one may take the view that they were short-circuiting things because the fairness point might have resulted in a proper and fuller consideration of all the aspects of the case that the mother wasn't going to advance because her instructions were very clear. So, my lord, my lady, I make that point, make of it what you will. In our submission, that is an important consideration for any local authority who has to be objective in its consideration of the evidence, because it's, in our submission, no good to say at the end of the case, well, there wasn't any evidence, when evidence wasn't explored that may have been explored. And so, my lord, my lady, that is one reference. There are other references as to other moments where, and they are indeed respectfully shorter periods where the mother is away from the child. But ultimately, as my lord or my lady said, that there were gaps in this evidence. There were gaps that led to the judge, in her final analysis, finding it difficult to reach conclusions. And one has to step back and ask why those gaps were there. And we say because there was short-circuiting of the process being undertaken. It's for the local authority, of course, that's right law to say, but nevertheless I will, that the local authority brings the case. They must ensure procedural fairness and they must prove the case. They must prove that it was the mother that was the person who inflicted or was negligent in the process of caring for her child. Indeed, my lord and my lady will note that the local authority and indeed those representing the children draw to the court's attention Her Honour's failure to deal with the issue of the list. And if I may just invite my lord and my lady to look at paragraph 52 of Re B, that's internal page 75, when the issue of the list is considered by Justice Peter Jackson, and when the list should be considered. Because, of course, in this case, what is effectively being said against Her Honour is that the list wasn't considered by her in her judgment. But in our submission, that clearly wasn't the intention of Lord Justice Peter Jackson. The intention, in any case, is that that is done at the earliest opportunity. It's quite plain from paragraph 52 that the consideration of lists is a case management issue. Those representing the child were present in, forgive me, I may be wrong, I'm not sure when Mr. Dewan joined the case, so I withdraw that in case it wasn't Mr. Dewan, but nevertheless, those representing the local authority and the child had every opportunity to, at an early stage, invite the judge to draw up a list, or to draw up a list of those that might be part of a pool, the possible perpetrators. Indeed, it is not what was anticipated, is that at the end of a case, a judge will be left to her own devices to formulate a list.
Well, who was saying there was anybody in the pool apart from the mother?
Well, the mother wasn't identifying a pool per se. She simply
The local authority was saying
Yep.
it's only the mother.
The local authority said it's only
the mother. The
Yep.
guardian agreed with that. Was anybody saying there's a pool of perpetrators here?
No.
Of which other persons should be included, or a list?
To be clear, my lord, the mother never said at any point there is a pool. She simply said it wasn't me, must have been someone else. Obviously, by default, if it wasn't her, it must have been someone else.
So the local authority aren't saying there are any other possible perpetrators. The guardian is saying there aren't any possible perpetrators, and the mother is saying there aren't any other perpetrators.
Indeed.
Because the father was.
So this wasn't.
So nobody was saying there were any other possible perpetrators.
Indeed, but at the end of the case, my lord, of course, the issue that's raised now is that there should have been a list. The judge should have investigated a list. If the local
Well,
authority...
that's not what the local authority is saying. It's not what the guardian is saying.
Well, they raised the issue...
They're saying that they're sticking to their guns. That there was only one possible perpetrator. So they're not saying there should have been a list.
Well, indeed, my understanding, and I may have it wrong, my understanding of what is being said is, in effect, the mother was the only person on the list, which then, of course, begs the argument about the pool of one, which one doesn't have. So, my lord, respectfully, they can't have it both ways. It cannot be said that the mother was the only one on the list, and that indeed has been said, and that the judge should have investigated the list. Those, in terms, are what is said in the skeleton arguments. So if there is to be, and it isn't,
Well, I think what's said is that the local authority, by the local authority guide, is that neither of those parties say there was another possible perpetrator. But if the judge thought there was another possible perpetrator, then she should have identified the list.
yes. Indeed, they say that, but of course they put the case on the basis that the mother is on the list and the only person on the list. That is what is said, my lord. And indeed, the issue of pool wasn't discussed at all in the case. So leading up to the case, it wasn't a consideration that was advanced by the local authority or by the Guardian. It was simply put on the basis, as my lord sees and my lady sees, simply put on the basis that the mother is the perpetrator. So it was a binary position that was advanced.
What is your position on the judge's finding? Did the judge find that the mother was a possible perpetrator?
Well, in the final analysis, in the perfected judgment, she didn't make that finding. No. In the discussion, of course, I have to accept that in the discussion she went elsewhere in the exchanges with with Mr. Chewin. But of course, my lord sees how I put it, and I don't seek to repeat all that's been said. But in
Just remind us of where you deal with that in your
forgive me, my lord.
document.
Yes, Lord, it's in the main bundle under our heading submissions. It's page 173, begins at paragraph 11, where we begin to deal with the court's findings. And then specifically dealing with the exchange point, Lord will see at paragraph 22, 21, forgive me, and then 22, 23, 24.
Yes, you say in paragraph 39, later on in your skeleton when dealing with ground 3, about line 10 on page 182, it is clear that the judge was of the view that an unidentified person was responsible for the injuries. That's your case.
Well, my lord, forgive me, it must be that if the judge ultimately reached the view it wasn't the mother, somebody has caused these injuries. So by default, it must be the case that somebody else caused the injuries. It must be inevitable. There is an inevitability about that statement, because if the mother didn't cause it, another did. But, my lord, we would say that that was an anticipated position on the basis that the mother had made quite clear throughout that she hadn't caused these injuries. That was not a new position identified during the hearing or during the evidence. The mother had laid that plainly through her statements as to her position.
So your case is that the judge made a positive finding that the mother was not the perpetrator.
In effect, my lord, we say that must be what she ultimately concluded. And those emails that my lord has been taken to already reinforce her position. Of course, this judge had had time to consider the oral exchanges at the end of a busy day and what she said. And of course, I can't seek to go behind what she says in the transcript. But she didn't introduce the idea of a pool. She was very much against the idea of a pool in those exchanges. My lord has seen what she said about there wasn't a pool. She didn't seek to advance the pool herself. She didn't think it was going to be helpful. She had effectively made a determination that she couldn't say it was the mother. If she couldn't say it was the mother, then it wasn't the mother. It's a binary position, my lord, we say, that either she identifies the mother as the perpetrator or she doesn't. It can't be put both ways. And so, my lord, we say that even though, of course, we can't go behind what the exchange was, that the court must consider what the judge ultimately determines in the cold light of day when she's got a transcript in front of her with her notes, because, of course, my lord would be aware, lady be aware, this is an extemporary judgment, and she makes that point in her exchange. I'm only going from my notes. And so the exchange is unhelpful in the sense that it's late on a Friday afternoon, she's only got notes in front of her, she's dealing with points being raised on the hoof with her, and the exchange, of course, I have to concede, is extremely confusing. It isn't helpful at all in terms of understanding the clarity of the judgment.
Well, let's. So you say we stick to the judgment.
Indeed.
The mother does not say, I find. Sorry, the judge does not say, I find it wasn't the mother. I find the mother did not cause the injuries, does she?
No.
You're saying it's clear that that is what she found.
Well, my lord, the process is binary. Either she says it's the mother or it's not the mother. And the wording that she uses is the wording that she uses. The choice of words is her choice. But what it amounts to, we submit, is that she didn't say it was the mother.
Yes.
Confusing and not seeking to play with words.
No. She didn't say it was the mother. Well, I think we can all agree about that. My question was whether she found that she doesn't say, does she, that the mother was not a possible perpetrator?
No, she doesn't say that. And nor should she take that approach, because even in a pool determination, exculpation is the wrong approach. You have to look at the evidence to, and of course we don't accept this as a pool case, but to exclude in that way is the wrong analysis of the law.
Why do you say it's clear that the judge was of the view that an unidentified person was responsible for the injuries? On what basis do you say that?
Well, my lord, it's in response.
Why do you say, where in the judgment is it clear that the judge was saying that?
Well, it's not said expressly, but by implication, of course, somebody caused the injuries to the child. And if it wasn't the mother that caused the injuries to the child, and if the court accepts our analysis that that isn't the finding the judge makes, then another must have caused the injury to the child.
Does she make that finding on a balance of probabilities?
She doesn't make that finding per se, my lord. I accept that those words are not used by the judge.
Well, you say it's clear that the judge was of the view that an unidentified person was responsible for the injury.
Well, perhaps poorly expressed on our part in...
How would you like to express it?
Well, Lord, simply to say that by default, of course, an injury is accepted by the mother to injuries, forgive me, to have been sustained by the child. If she didn't cause the injuries, then another caused the injuries. She doesn't know who and she doesn't know how. That's her simple case.
So your proposition is that there was, in fact, a list. The mother and an unidentified person. The judge excludes the mother as a possible perpetrator.
I don't disagree with that analysis.
And leaving the unidentified person.
I don't disagree with that analysis, my lord. Yes, indeed, it must follow that if the mother says she didn't do it, that another did, and indeed the list is therefore, in essence, there. But that's an implication in the local authority's case, to plead the case that way, knowing that the mother has said, I haven't done this, that there are a number of conclusions that can be drawn. And one of the conclusions that can be drawn at the end of the case is that the judge is perfectly entitled to say, well, I've heard her evidence, I've listened to the evidence, I've considered all of the evidence, I've read widely in this case. And of course, respectfully, Lord, I say that this court, jumping on if I may, and I'll come back, but when being asked to substitute in a determination, does not have the breadth of information that the judge had. She clearly had the breadth of information about this family. She had the benefit, more usual than unusual now, of a full parenting assessment. She had the benefit of extensive contact notes over a very prolonged period of time, very detailed notes of the exchanges and interactions between the mother and the children. She had the benefit of observing, reading, understanding the mother. She had the benefit of not a single person raising any complaint or concern about this mother and how she interacts with her child. No evidence of stress in the usual way that one might see the list of stressors. There was no such evidence in this case, nothing to indicate concern, only evidence on the papers, and nobody challenged this, of a loving, warm relationship, 9 days of observation of the mother in the hospital with the child, not a single concern by any professional at any point. Indeed, the mother was a relaxed parent, an experienced parent, a parent that wanted this child. So when one often looks at the stressors as identified, none of those were present in this case. In our submission, of course, that was very compelling evidence. And Lord of course, we say that one has to look at the totality of the evidence, as the judge did, the broad canvas, and I disagree with submissions made on behalf of the local authority that the judge failed to look at this critically and to look at the aspects of the case where the mother, in her analysis, that raised concerns in relation to findings. She did indeed do that. She raises in a number of places her concerns about the mother, a lack of curiosity, for example, in relation to how the injury was caused. Of course, on behalf of mother, we didn't accept that she lacked curiosity. Mother had said that she didn't know. One can extrapolate from that many inquiries have been made over time from family members, etc., for her to reach such a conclusion. The judge expresses concern about the lack of explanation. These are all points that are criticisms of the mother in undertaking the balancing exercise to reach a view. But she was driven in our submission to a clear view that this was not a mother that she could identify as a perpetrator to have caused these very serious injuries to her child.
Well, given her findings that the mother had withheld information and her findings that it's inconceivable that the mother could fail to notice the swelling, highly unlikely that she would miss signs of behaviour, on what basis do you say that she excluded the mother as a possible perpetrator?
Well, my Lord, the wording that she chooses herself is the wording that the court is, unless the issue, of course, is revisited, is the wording that we don't seek to go behind. And, of course, paragraph 73, forgive me, my Lord, if I may just turn it up. Is the critical paragraph in her judgment. Forgive me, paragraph 72, where she simply says, I'm unable to make a positive finding that the mother herself caused the injuries. In our submission, that can only mean one thing, that she's not able to say that this is the perpetrator. The whole purpose of the exercise, when one is undertaking a fact find, is to ask the when, why, how.
My question, forgive me for interrupting you, my question was to her excluding the mother as a possible perpetrator, which you say she did.
Well, my Lord, I interpret her wording in paragraph 72 to be that she's unable to make a positive finding that the mother herself caused injuries. If my Lord intends to read that alongside the commentary that she gives,
well, that's the trouble. That's, I think, you've got to address this, haven't you? As I've said, at least 3 times in the exchanges with Mr. Tuam after the hearing, after the judgment, the judge indicated that she was making a finding that the mother was a possible perpetrator.
Yes.
So and that's what she meant to say.
Well, my Lord, yes.
I'm paraphrasing what she said.
No, of course.
I hope accurately. Please go to the passages if you wish. But what do we do with that?
Well, Lord, I accept that that is a significant challenge and causes complications in this case. However, and the however is that this judge, who is conscientious and careful, had an oral exchange, which of course I accept on behalf of the mother is unhelpful to an understanding of what she intended. But nevertheless, in our submissions, she had the opportunity, once the transcript was available and she was sitting behind her desk, to think about what she really intended to determine in this case after 4 days of evidence and consideration. Not in a few minutes of exchange with advocates at the end of a busy week. And so, my Lord, I think in our submission, the only safe way to deal with the second transcript is to set it aside.
To ignore it.
Ignore it. Because one can't attach weight to what is said unless the judge followed on and incorporated that into her judgment, because it's the judgment that is challenged. It is the final analysis of the judge in that document that is challenged, not an exchange in the way that is proposed. Although I have to concede it's extremely unhelpful that that exchange happened. But in our submission, the judge led herself into a degree of confusion because the issue of Paul was obviously raised by Mr. Chewan, and I don't suggest improperly in any way, but it was raised by Mr. Chewan at the end of a long day, and she confused herself. And I make that submission, my lord, because it must follow that she confused herself, because otherwise she would have incorporated it into her judgment as invited. And albeit she said in fairly robust terms, no, that's what I intended, no, that's what I meant, it's obvious that's what I meant, it clearly wasn't, because she didn't put it into her final judgment. And in the cold light of day, in our submission, that is a brave thing for a judge to do, because ultimately her job is to do the right thing, rather than the expedient thing of, well, I had that exchange, so I better just pop it in, because she has to respectfully base her conclusions on the evidence and the determination she reaches from that. So it can't be safe in our submission to rely on that, because, of course, and Lord, of course, I hear what he said about email exchanges. Those limited exchanges are there, and the inquiries were made. And I pause just to make a comment that, of course, it wasn't the local authority that at any point, albeit they say to the court now, well, of course, we can't do a safe risk assessment because we didn't have clarity about the judgment. They weren't asking for that clarity. At the end of the judgment, indeed, and one obviously accepts that council may need time to reflect and consider, but by the 25th of June, when the local authority were writing, they weren't writing on their behalf. They were saying, well, actually, Your Honour, would you mind just clarifying this, because the Guardian's asking about this, and, you know.
Is it your case that the judge was therefore going back, when she went back to the task, it was finding that the mother did not cause injuries, but knew who did?
I think that must be, in my submission, our analysis of what she says, because I can't go behind her wording in paragraph 72. She's chosen those words, and she's chosen those words for a reason.
If that's right, why then did she say in the second email exchange, page 34, that neither of the alternatives in the email from the local authority solicitor was an accurate summary of the findings I made? Because one of the options put to her was that you were finding that the mother did not cause injuries, but does know who did, and has lied to the court about that. I mean, your case is that is what she found, and that she says that it isn't.
Well, Lord, again, I have to come back to the point about email exchanges and the brevity of what she says. Without being in the judge's mind, I can't comment. I don't know how carefully she read this email, for example, whether that was her clear intention. Without a properly expanded, and forgive me, my lord, I'm not trying to be impertinent, but it's an important point, because in the usual way, when one has a judgment that is deficient, it is properly expanded upon. Points are made in writing. The judge then has an opportunity to reflect on those. And I make no criticism of anyone in this case, of course, but it is unusual for us to have had myself, I wasn't even in the courtroom, I was on a link and only heard some of it. But yeah. In any event, there was no comeback on that. Nobody expanded and said to the judge, well, rather through a solicitor in an email, because this came by way of email, so the judge responded by way of email, but actually could we have a proper explanation expansion? Many of the points that are now raised as criticisms of the judge and what she should have determined, for example, in the local authorities document, were not raised with her. There was no point raised with her by the local authority other than one point that was raised. And that was accepted when the judge says, well, I'm not going to make that particular finding, I don't think I need to. And so the proper mechanism for expanding on a judgment and clarification was not exercised. Therefore, my lord, forgive me, and I say I'm not seeking to be flippant, I can't be in the mind of the judge to understand what she meant. Maybe she did intend to say exactly what he said in the email. I simply don't know, because it doesn't form part of her judgment. And for those reasons, my lord, I'm cautious on behalf of the mother to say something other than the interpretation we put on the analysis. Of course, I accept it would have been very helpful for there to have been a broader and fuller expansion of the judgment and for there to be proper clarity from the judge in her own words as to what occurred. And I entirely accept that that was sought on behalf of the children, and regrettably, all we have are the two brief emails. But the brief emails, as I say, forgive me for repeating myself, come because indeed I fully intend to defend the judge on this point as a result of an email to her and not a proper request for clarification of her judgment.
Ms. Andrew, may I just ask a question, please? Just going back to the first sentence of paragraph 72.
Yes.
One reading of that is that the judge is unable to find on the balance of probabilities that the mother caused the injuries. But that sentence leaves open the possibility that the mother was a possible perpetrator. Would you accept that that sentence is open to be read in that way?
My lady, I would accept it if we took that sentence in isolation, but when one reads the whole judgment and looks at the judgment in its totality, and one looks at all of the references, and I can take my lady, my lord, to the references, what one is left with in the analysis of this judgment is a very positive view of this mother by the judge in terms of the issue of was she the perpetrator. The judge makes comments about her being a loving, caring mother. She talks about, forgive me, I think it's paragraph 65. May I just find that? Yes, at paragraph 65. If I could invite my lady to look at that paragraph, where she talks about the warm and close parent-child relationship. And then the end of that paragraph in our submission is an important one because she then goes on to say the factors do not all point in the same way, but the balance very much falls towards the protective end of the spectrum in this case. That forms a substantial body of evidence which decreases the likelihood that the mother herself was the perpetrator of the injuries.
Decreases but doesn't exclude.
I accept that. But the general submission I make is that if one looks at all of this judgment together, rather than different parts of it, it is clear the direction of travel and what the judge was intending in relation to this mother. Through all of the many comments that she makes about this mother, her care of the child, the quality of her care of this child. And indeed, of course, she points to the fact that there are gaps, not using the word gaps, but going back to paragraph 42, I find myself in this position also because I'm quite clear that the court has not been given a full and complete account in this case of what happened to in A's life over the relevant period. I accept, of course, she's referring to my client in relation to that part.
Yes, because nobody else was given evidence.
I accept that. But of course, the judge has to proceed on the evidence she has, and these are the conclusions she reaches. I say in a balanced and fair way with proper analysis of the negatives as well as the positives in relation to the mother. And that line at the end of paragraph 65 in our submission is highly significant because she is considering the body of evidence, that which, of course, respectfully, this court does not have, that decreases the likelihood of the mother herself being the perpetrator of the injury.
So one reading of that is that it supports her finding that she can't make a positive finding that the mother caused the injuries. But all I'm suggesting is it doesn't necessarily exclude the possibility that the mother was a possible perpetrator, as opposed to, on the balance of probabilities, the perpetrator. Again, I think it comes back to the pool argument and where we are on the pool argument, in that the case wasn't presented as a pool case. It was presented as the mother is the perpetrator, and even though the mother's case had been set out in writing repeatedly, it was presented as the mother is the perpetrator, and the judge did not reach the conclusion that she could say the mother was the perpetrator. Again, I'm trying to choose my words carefully and not go behind what was said. And of course, I think I have to accept objectively that there is some ambiguity in what is said. I'm not seeking to use words cleverly or in a way that is unhelpful to the court. I do accept that there are ambiguities in the conclusions and the words that the judge chooses, and perhaps she chooses those words for her own reasons and they're not amplified sufficiently for us to all understand them. But what I submit on behalf of the mother is that in any analysis of all of that, she has not said that the mother is the perpetrator.
Could you tell me what your submission is about the last sentence of paragraph 73? 73 is about, I do make the finding that mother knows, etc. That's inescapable. Yeah. And then the last sentence is the threshold criteria are met on that basis.
Yes. Yes, and I think this was expanded upon in the exchange with Mr. Tuan later on. I mean, our submission, of course, is that the judge took a different view of the case in that she hadn't made the determination that the local authority anticipated, and I say that respectfully, but anticipated she was likely to make by saying that mother was the perpetrator. She didn't take that view. That, in our submission, speculatively might have taken local authority somewhat by surprise. But nevertheless, the judge was very clear that the threshold had been crossed. And in the mother, not, as she determined, not coming clean, if I can use that expression, about what she knew, she took the view in our submission that that was a very serious issue, that would place a child at risk. There would be a likelihood of risk in the future to that child if the mother wasn't telling the truth and being open and honest about very serious injuries to her child. And so, of course, we submit that the threshold is very clearly crossed on that basis. There's no question that the threshold is crossed. And I don't think anyone suggested, of course, the order was drafted by the local authority at the end of the case. And indeed, of course, the judge is being criticised again for the ambiguity in what she determined and referencing the judgment. But in the usual course, one sees at the end of a judgment a document, a freestanding document, that sets out exactly what the judge determined. Unusually, we don't have that in this case. And that is because it wasn't presented to the judge in that way. Well, here's your judgment, and here are the findings that we expect you to see. You see that through the skeletons that are before the court. And again...
And in relation to that, the threshold criteria are met, and you say quite clearly they were, and she was right in relation to that. I think the criticism, perhaps, is being raised. So what is the risk? A dishonest parent? What do you say about that?
Well, my lady, it's simply this, that it isn't... The issue of dishonesty is part of the significant central issue, and that is a child suffered very significant injuries. And if a parent who the judge concluded knows that those injuries occurred, and one speculates perhaps he knows how those injuries occurred, I don't concede that point because, of course, it's possible that she was given some information, but not all. I'm speculating, I don't know what was in the judge's mind. But if that were the case, then that is a very serious determination. The parent has knowledge. They don't share that knowledge with the court, with the local authority. That is a serious risk to a child. And the conclusion of that is that there will be likely future risk because of the lack of openness. When one has such serious injuries with a young child, of course, this was a mobile child, but she wasn't fully verbal. She's 9-10 months old. Those children, of course, attach to themselves in these proceedings greater significance because they can't fully articulate. I think the child had some language, but not full language. But they are more vulnerable. Of course, the child's moved on in age, but the point is, of course, with very serious injuries, if a court determines that a child has sustained those injuries and the parent knows how, or indeed has some knowledge and fails to share it, that is a serious finding that, of course, we say increases the likelihood of risk in the future because they've kept the information from public authorities, indeed the court.
Thank you.
May I just change and turn my back? So far as the final issue of how the court should proceed, does my lady require me to address you in relation to that? Of course, I'm going to argue...
Well,
It would be helpful.
Yeah.
If we were to allow the appeal, contrary to what your main submission is,
Yes.
Your case is a rehearing.
Well, my lord, I say, of course, there must be a rehearing because procedural fairness would require there to be proper and full consideration of this issue. To simply substitute in a decision when a judge who so carefully considered the evidence gives a determination about a parent in this way that is not wholly but largely a positive analysis of the parent and reaches her conclusions as she does at paragraph 72, in our submission it would be wholly unfair for a court to substitute it in that way. Of course, interference with a judgment or a court's determination at first instance is something that, of course, my lord and my lady will know you will be slow to interfere with in any event, let alone to go to the next stage of granting the appeal but then substituting in an alternative decision. In our submission, that simply would not be fair in this case and wouldn't meet the justice of the case. There should be proper reconsideration of the issues in this case and a proper analysis of all of the evidence. The submission that's been made, well, of course, the mother's not going to change her position. In our submission is a very limited and fixed view. Of course, everybody reflects. One anticipates any parent will reflect. But even if the mother continues to say, I don't know, the court needs to look far more broadly. For example, the court will be aware that just as the case began, there was a great deal of police disclosure that came in and the position of the father. And I'm not seeking for a moment at all to suggest that...
A rehearing would involve consideration of a lot of evidence,
Indeed.
Much of
Yes.
which, or some of which perhaps wasn't looked at
No, at all.
Or in the same way.
Indeed, and some that was just touched upon because it came in at the last minute And indeed, as the court will be aware, and again, I'm not seeking to draw the father into any pool, forgive me, I'm not, but just to address the point that's been made that when the court looks at it, the court will have to look at it fully, and the father was then having to give evidence effectively on the hoof as to issues that were raised in documents that were literally coming in as the case started. In fact, may have actually come in the week that the case began, but text messages and so on and so forth. And so proper consideration of the full ambit of the evidence in our submission would ensure that there is proper fairness in the case, where the consequences are very serious, a potential permanent separation of a mother and child. Unless I can insist.
Thank you. Ms. Seatler.
My ladies, my lord, on behalf of the father, he takes a neutral stance on the appeal that's before you. He would like me to say on his behalf that the children continue to live under restrictions in terms of contact, etc., and they really need some progress. And this is difficult for them, especially the older children.
Yes.
But his position is neutral in terms of the appeal, and unless I can help you in any other way.
Thank you very much indeed. Mr. Turin.
Might I briefly deal with a few points? The short-circuiting of the process and the gaps. It eludes me, and it's probably my fault, but it eludes me as to what a local authority, a guardian or a court should do when faced with this mother's evidence. It does not require a mother to quote-unquote point the finger. But if the mother was able to give some evidence of for example, a collapse in the child following a serious brain injury, or a fitting in the child, or illness in the child, that might point to others being on the list. But as has been teased out by Lord Justice Baker, no one was saying there should be anyone else on the list. And the pointing by Miss Ancliffe to the mother's statements is only a pointing to opportunity, not evidence of being on the list. So there was no short-circuiting of the process. It was carefully considered. If there was a short-circuiting of the process, ultimately that's the judge's responsibility, but that's not a criticism I make of her. There were also no gaps. I want to remind the court about the sequence in Re B, about the making of the list. The first is that there is a list. And if there's one person on that, the first, when considering perpetration, forgive me, the first is make a list. There can be one person on that list. I heard Miss Ancliffe to be critical of a list of one. A list of one is not the same as a pool of one. A list of one is only the first stage in the conclusion of a pool, because you make the list. This is paragraph 49 of Re B, authorities 75. You then consider, can you make a perpetrator finding? And only then do you turn to pool. And it was agreed that there was a list of one, notwithstanding the opportunity. So that is not a fair criticism of the process as mounted by Miss Ancliffe. Miss Ancliffe says that there was no comeback and no proper clarification process. At page 27, electronic 29 of the transcript of clarification conversation, it was expressly said by the judge to me that the judge, I'm now paraphrasing, get me the transcript and I'll perfect it. I said, thank you, and we left. It was only after the transcript was received and we sought clarification of the perfection that we realised there had, in fact, been no material change to the transcript. I'm not sure what else we were meant to do. We are very much aware of the authorities on clarification and the desire to avoid correspondence. We asked, was there anything else on receipt of the transcript? And the judge came back and said, no, that is it. It's paragraphs 72 and 73. So there was no fault on the part of any of the parties in relation to comeback or clarification. Penultimate point, you'll be pleased to hear, my lady, is the remedy, the disposal and the outcome. Ms. Picos reminds me that we're in the 64th week. And that is a strong point. What I simply say, I want to pray and aid and adopt, if you will allow me, Mr. Toomey's submissions on this. What I simply say is that the court should deal with now are the facts and the evidence now, not what they might be. The mother might change her evidence. The mother might change her position. Mr. Toomey's right. That can be dealt with in assessment. It can even be dealt with by reopening. But there is no sign of it. And now, substitution is appropriate. It still is discretionary. It's not compelled. And my final point is this. When the court retires to consider the case, and having heard Miss Ancliffe's defence of the judge, as I stand here on behalf of the children, I want to ask the question, who caused these injuries? And I simply don't know. There are possibilities that we've explored, but I don't know who caused these inflicted injuries. And that cannot stand. Can I assist further?
No, thank you. Thank you very much indeed.
Thank you.
Have we dealt with all outstanding pieces of string?
I believe so. From my perspective, certainly.
Thank you.
Thank you.
Well, thank you very much indeed, all of you and everyone behind them, for the presentation of this matter and all the work that's gone on. Thank you too for dealing with this at relatively short notice, this important issue that's before us. As you will be fully aware, in this court, we very rarely give an extempore judgment rather than the judge in this case, and we're not going to do so today on these very important matters. Our draft judgments will go out in the usual way for consideration only as to typographical errors and obvious mistakes. There will be no interchange on the email about them. But we're grateful to you for those picking up of those kinds of errors. And as you're also fully aware, in this court, judgments are handed down nowadays electronically, yes. But you will be asked if you can agree an order, and if not, that you should put in very short written submissions, and we will decide the consequential order on that basis. I want to also just remind you, in relation to the transcript, that it's very important that it doesn't go beyond the circle of those who've already given email addresses to our clerks, and that is of particular importance, as you'll appreciate. We're extremely grateful. Thank you very much.
Court rise, if able.